Welcome back to the Deep Dive. Today we are wading into some seriously complex legal waters. We're looking at the emergency docket of the Supreme Court, which some people call the shadow docket,
Right.
and specifically an intervention that is, on its face, purely procedural, but one that has these absolutely profound, immediate implications for millions of Americans.
That's exactly right. Our mission today is to unpack the Supreme Court's November 2025 order in a case called Trump v. Orr.
Okay.
And this is an instance where the government came to the court asking for an emergency stay. They wanted to enforce a highly controversial new policy from the executive branch.
And this is all about how sex and gender markers are recorded on U.S. passports.
Exactly.
So we have the actual legal documents in front of us. We've got the very brief, very narrow order from the majority.
And then the extensive, and I mean highly critical, dissent written by 3 of the justices.
Okay. And for you, the learner, our goal here is to use these sources to show how a seemingly simple procedural question, does the government get to pause an injunction? How that actually reveals these massive conflicts.
It's about legal standards for sure, but it's also about deep political motivations.
And most crucially, what this means for the immediate safety and rights of citizens on the ground.
It's a perfect, if maybe painful, illustration of how a procedural mechanism can end up dictating the real-world outcome. It allows a challenge policy to proceed for potentially for years before its constitutionality is ever fully settled.
Okay, so let's unpack this. Let's start with the absolute basics. What exactly was this policy that was being challenged, and what did the plaintiffs do about it?
Right, so the policy itself came from an executive order, number 44168, and it mandates that all new passports must display an individual's biological sex at birth.
Which was a massive change.
A huge reversal of a multi-decade administrative practice that had for a long time allowed transgender Americans to get documents that were congruent with their gender identity.
Okay, so the lawsuit, or et al., this was a class action filed by transgender Americans.
That's right, in the District Court of Massachusetts. And they were challenging this new rule on, a couple of grounds: discrimination and improper implementation.
And they had some early success.
They had a critical early victory. On June 17, 2025, the district court granted a preliminary injunction.
And an injunction is basically a stop sign.
It's a temporary stop sign, exactly. It prevented the government from enforcing this new birth sex policy nationwide while the main lawsuit was proceeding.
So the government obviously wasn't happy with that. They appealed.
Immediately. And they appealed to the First Circuit Court of Appeals, and that court refused to stay or pause the district court's stop sign.
So they struck out twice.
Twice. Which brings us to November 6th, 2025. The government, having lost in the district court and the circuit court, goes directly to the Supreme Court.
For an emergency stay.
And the court granted it.
Meaning the policy. It's now in effect.
It's now in effect. The policy requiring sex assigned at birth on new passports is active across the entire country. And it will be, while the case continues its, very lengthy journey through the First Circuit and maybe years from now back to the Supreme Court.
And the immediate result of this one-page order is that the plaintiffs and the whole class they represent, they lost that temporary protection they'd had since June.
Immediately. They are now exposed to the policy's consequences.
Wow. Okay, that sets the legal stage. Before we get into the, the razor-thin arguments for granting the stay, we have to establish the baseline. What was overturned here? The dissent keeps talking about 33 years of settled practice. This wasn't some minor administrative tweak. It was a fundamental overhaul. So let's look at the history of how passports have actually treated identity.
Understanding this 33-year trajectory is absolutely essential, not just for context, but because it's the whole basis for the Plaintiffs' Administrative Procedure Act claims, their APA claims. For decades, the State Department had policies that progressively accommodated gender identity for passports. And it reflected this primary understanding that the purpose of a passport is to attest to the bearer's identity and nationality today.
Right, that distinction identity today versus a historical fact. That feels key. So take us through that evolution starting back in 1992.
Absolutely. So phase 1 really begins in 1992. Even back then, the State Department recognized that a person might need a passport with the sex marker different from the one assigned at the birth.
So the idea wasn't new.
The principle was there, but the requirement was really stringent. Applicants had to submit evidence of surgical reassignment, So accommodation existed, but it was a contingent on these, really invasive medical procedures.
Okay, so even 33 years ago, the government acknowledged that documentation should maybe reflect something other than what's on a birth certificate, even if the hurdle was incredibly high.
Precisely. It shows the purpose was never purely about attesting to one specific, unchangeable biological fact. It was about the recognized identity of the person holding the document.
Okay, then what happened next?
So in 2010, we get to phase 2. The State Department moved away from requiring surgery.
That's a big deal.
A huge deal. Instead, applicants just needed to submit a doctor's certification. This letter would state that the applicant had undergone, quote, clinical treatment for gender transition.
So no surgery required, just medical documentation.
Right. And it was a crucial administrative step. It recognized that proof short of full surgical reassignment was enough to prove an identity transition for the purpose of a passport.
And that shift from surgery to certified clinical treatment, that must reflect a broader, societal and medical understanding of gender identity.
It absolutely does, and it streamlined the process a lot. Then we get to the most recent shift, phase 3, which started around 2021.
And this was the biggest change yet.
The largest change, yes. The policy allowed applicants to simply self-select the sex marker that matched their gender identity. No doctor's note, no proof of surgery.
Just self-attestation.
Right. And the decision was based on this premise that, for the purpose of a travel document, the individual's affirmed gender identity is the most critical aspect for identification and for security.
And all this was happening under the official federal definition of a passport, which, as the sources keep reminding us, is just to attest to the identity and nationality of the bearer.
Precisely. If the primary function is identification, then matching the document to the bearer's current presentation, that just streamlines security. It reduces friction.
Which brings us to January 2025, where this entire 33-year trajectory toward, more administrative flexibility, it just gets abruptly reversed.
Completely reversed. And the reversal didn't just target that 2021 self-selection rule. It went all the way back. It essentially now requires documentation of the sex assigned at birth no matter what, regardless of any subsequent medical or legal transitions.
Wow. So how did this happen?
Well, on January 22, 2025, the State Department implemented the new policy. But crucially, this wasn't an independent decision they made.
It came from higher up.
It was directed by Executive Order number 12168, which was issued just 2 days earlier by the president.
And the language in that executive order, that's what makes the equal protection claim so compelling, isn't it? It goes way beyond just administrative requirements.
Oh, it is absolutely central to the legal challenge. The order characterized transgender identity in very specific, very politically motivated terms.
Like what?
It labeled it as false and corrosive to American society.
Corrosive.
Mm-hmm. The order asserted that the policy of the United States is to recognize two sexes, male and female, and it defined that based on the sex assigned at conception.
At conception. That is an extremely rigid and specific biological definition to be codifying into administrative policy for a travel document.
It establishes a very clear political intent behind the rule change. The order then directed the Secretary of State to make sure all new government IDs reflected this specific definition of biological sex.
Okay, a quick point of clarity on the scope. This policy, it only applies to new passports, right? So existing gender-congruent passports are still valid until they expire.
That is correct, and it's a detail the dissent will weaponize later.
I can see why.
If you got a passport matching your gender identity in 2022 under the old rule, you can use it until it expires. The new policy only affects new applicants or people seeking renewals.
Okay, that sets the scene for the conflict perfectly. We've got this long administrative history being completely overturned by a very politically charged executive order. So let's move to Section 2, the legal battleground.
Mm-hmm.
What were the plaintiffs' arguments that were so successful that convinced the district court to issue that injunction in the first place?
Mm-hmm. The plaintiffs' class action challenged the policy on two major fronts. You have the constitutional and the administrative.
Let's start with the constitutional.
Okay. First, the constitutional challenge was under the Equal Protection Clause. They argued the policy unlawfully discriminated based on sex and that it lacked a rational basis.
Yeah. Okay, rational basis. And for you, the learner, when we talk about that, we're talking about the absolute lowest standard of constitutional review, right? The government almost always wins these.
They almost always win. They just need to show the policy is rationally related to a legitimate government purpose, a very low bar.
But
if the court finds that the only purpose is to harm a politically unpopular group, which is the legal definition of bare animus, then the policy fails even that low bar.
And the corrosive language from the executive order, that's the ammunition.
That's the smoking gun, they would argue. It's direct evidence of discriminatory intent.
Okay, so that's the equal protection claim. What was the administrative challenge?
That was under the Administrative Procedure Act, or APA. The APA governs how federal agencies do their jobs. And the plaintiffs claimed the State Department's reversal was arbitrary and capricious.
What does that mean in plain English?
An agency is arbitrary and capricious if it changes a long-standing policy without giving a reasoned explanation, or if it fails to consider all the relevant data and consequences.
And here, the dissent pointed out, there was zero explanation for its reversal of 33 years of practice.
Right. So the argument is, you can't just flip a switch on 3 decades of settled rules without documenting why you decided the old way was wrong and, importantly, what consequences you considered, like the safety issues.
Which they didn't do.
They didn't. They also had a smaller APA claim about the Paperwork Reduction Act, which requires a 60-day notice before you change government forms. It just kind of speaks to how rushed the whole thing was.
Okay, so now we pivot to the Supreme Court's intervention. The majority, without a ton of discussion, grants the stay. They apply what they call familiar stay factors. So let's analyze how they justified this, how they overrode 2 lower court decisions.
The majority's reasoning really hinged almost entirely on the first factor of the stay analysis, likelihood of success on the merits.
Meaning they had to be pretty confident the government was going to win the case eventually.
Exactly, on both the equal protection and the APA claims.
Okay, but how do they manage that on the equal protection claim? Given the really harsh language in the executive order, doesn't that language itself prove animus?
The court adopted a highly deferential and very narrow view of the policy's purpose. They framed the issue not as one of discrimination against transgender people, but simply as a government decision about what information a travel document should contain.
And that's where the analogy comes in.
Right. The majority held that displaying biological sex no more offends equal protection principles than displaying their country of birth.
So their central argument is, birth sex is just a static historical fact. It's like your birthplace.
Yeah.
And therefore, it can't be discriminatory just to record it.
Exactly. The court stated the government is merely attesting to a historical fact without subjecting anyone to differential treatment.
And they cited a precedent.
They relied heavily on the precedent from Trump v. Hawaii. That was the travel ban case. And in that case, the court established that to prove animus, plaintiffs have to show the policy lacks any purpose other than a bare desire to harm a politically unpopular group.
So that bar for proving bare animus is just incredibly high.
Almost impossibly high. The majority is essentially saying that even if the president used aggressive rhetoric, the policy itself, the act of recording birth sex, has a facially neutral, legitimate purpose.
Which is what? Identifying the bearer with fixed data points.
That's the implication. They're giving heavy deference to the executive branch's stated purpose for the document, and they're kind of compartmentalizing the policy away from all the rhetoric surrounding it. It allowed them to just sidestep the animus question, at least at this early stage.
Okay, that's equal protection. What about the APA claim? How did the majority argue the State Department was not arbitrary and capricious, even though the agency provided no rationale for reversing 33 years of practice?
This is a really crucial procedural defense they found. The majority found a legislative shield for the State Department.
A shield?
Yeah. They argued the department was likely not arbitrary or capricious because Congress had expressly required it to follow presidential rules under a specific statute.
Okay, you have to break that down for me. What statute is that?
It's 22 U.S.C. Section 211.
Yeah.
And you can think of it as a clear line of authority from Congress to the president, specifically about passports.
So what does it say?
It says essentially that the Secretary of State is authorized to grant and issue passports under such rules as the president shall designate and prescribe.
I see where this is going.
Right. The majority interpreted this to mean that the State Department wasn't engaged in independent rulemaking here. They were just complying.
Yeah.
They were in mandated compliance with the president's order, EO 14168.
So the argument is, if the president orders an action, the agency's implementation of that order can't be arbitrary, because they have an explicit legal instruction to follow the president's rules. That's a powerful way to neutralize an APA challenge.
It really is. It shifts the legal fight away from the agency's process and onto the president's constitutional authority, which is a much, much harder thing to challenge at this preliminary stage.
Okay, so the majority thinks the government is likely to win on the merits. What about the second critical factor for granting a stay? Irreparable injury to the government. Why was this delay so harmful to the federal government that the Supreme Court had to step in immediately?
The majority characterized the district court's injunction as this intolerable intrusion on executive authority. They pointed out that the relief was class-wide, meaning it enjoins enforcement of an executive branch policy with foreign affairs implications concerning a government document.
And passports are the quintessential foreign affairs document.
Absolutely. The majority concluded that without a stay, the government will suffer a form of irreparable injury. They cited another precedent for this, Trump v. Kaisia, Inc.
And the logic there is?
Yeah. The logic is that the ability of the executive branch to execute its own policy priorities, especially when they touch on national identity documents, is inherently tied to sovereignty. So preventing the president from exercising this authority is a harm to the sovereign power itself. And that justifies immediate intervention.
So the injury is almost an abstract one. It's the harm of not being able to do what the executive branch was told to do.
Mm-hmm.
So the injunction is stayed, the policy is back in effect, and the government gets to enforce its preferred definition of identity for new passports for potentially for years.
That is the procedural reality. The stay is comprehensive. It keeps the policy alive until the entire legal process is over, which, as we know, can take a very, very long time.
And now, this is where it gets really interesting, because the dissent just calls this entire rationale into question. Justice Jackson, joined by Sotomayor and Kagan, wrote this devastating dissent, arguing the court fundamentally misunderstands the assignment.
That specific phrase is the absolute heart of their critique of the emergency docket. The dissent is arguing that the court is treating this exercise like a back-of-the-napkin prediction of who's going to win the lawsuit,
When that's not their job here.
when their job in a stay application is much more constrained.
So what is the actual job of the court here, according to the dissent?
They remind the majority that a stay is a form of extraordinary, equitable relief. The whole purpose is not to predict the winner. It's to determine if the applicant, in this case the government, has justified extraordinary intervention.
Because they're asking for the highest relief possible at the earliest stage.
Exactly. And this requires the established four-factor test from a case called Nunkin v. Holder.
And what are those four factors?
You have to look at 1, likelihood of success, 2, irreparable harm to the applicant, 3, the balance of equities, so relative harm, and 4, the public interest.
And the dissent's main charge is what?
That the majority focused almost entirely on factor 1, likelihood of success, and factor 2, that abstract sovereign harm, and they willfully ignored the equitable balancing required by factors 3 and 4.
So the accusation is that the majority granted the stay because they liked the government's legal argument, not because the government had met the incredibly high bar for demonstrating urgency and irreparable harm.
That's it in a nutshell. The dissent argued the majority failed to spill any ink, considering the plaintiff's documented harm. They intervened without proper equitable justification, and they permitted harm to be inflicted on the most vulnerable party.
And they call this an unfortunate pattern.
They did, an unfortunate pattern in how the court has been handling the emergency docket.
So this is moving beyond just a legal disagreement. It's a critique of how the court is using its own procedural power.
It is. The dissent calls this outcome a senseless sidestepping of the obvious equitable outcome, leading to a pointless but painful perversion of our equitable discretion. And to back that up, they just systematically dismantled the government's claims of immediate irreparable harm.
Okay, so let's get into that deconstruction.
Mhm.
The government said the injunction forces the government to misrepresent the sex of passport holders and contradict biological reality. How did the dissent shoot that down?
They called these contentions far-fetched. The dissent argued that just preventing the president from immediately implementing his preferred executive order, that's not enough to count as irreparable harm. Lower courts issue injunctions against the government all the time.
Right, it's not an automatic injury just because the executive branch is told to stop.
Exactly. And this is where the scope of the policy itself comes back to haunt the government's urgency claim.
Ah, right. The fact that it only applies to new passports.
Yes, this is a brilliant tactical point by the dissent. They pointed out that the government's claim of some urgent foreign policy crisis of misrepresentation is completely undermined by the fact that the policy itself allows existing gender-congruent passports, millions of them potentially, to just keep being used until they expire.
So If the government is okay with these so-called misrepresenting documents being valid for years, how can delaying the issuance of new ones be an urgent, irreparable sovereign injury?
It creates this massive internal inconsistency. And on top of that, the dissent stressed that the government offered zero evidence, none of harmful confusion or other problems caused by gender-congruent passports over the last 33 years.
If anything, it probably helps.
In fact, security and identification are likely aided when the document actually matches the person's lived identity. The dissent concluded the government completely failed to articulate any way it would actually be harmed by just delaying the policy until the litigation is over.
It sounds like on that factor alone, the government failed the Nicon standard entirely, which should have been enough to deny the stay, regardless of who might win the full case down the road.
That is the dissent's core procedural argument. But they didn't stop there. They went one step further and revisited the merits arguments, saying the majority's confidence that the government would succeed was unfounded.
On both the APA and equal protection fronts.
On both.
Okay, let's break down their merits rebuttal. On the administrative side, why did the dissent feel the APA violation was still likely, even with that presidential mandate statute?
The dissent argued that just because you're complying with a presidential order, that doesn't give the agency an end run around all APA requirements. They stressed that the policy is likely arbitrary and capricious because the State Department did not consider all the relevant aspects before reversing 33 years of practice.
And they cited a case for that.
They cited a major precedent, Regents of University of California, which holds that even when an agency is bound by a superior's directive, it still has to consider all relevant aspects of the problem.
So even if the president says do this, the State Department still has a legal duty to show they thought about the safety consequences, the administrative costs, the existing precedent before they acted.
Absolutely. The State Department provided zero explanation of how they addressed the documented harm or the 33 years of prior policy. So they were sloppily complying, and that sloppiness is an APA violation.
And on the equal protection side.
The dissent just noted that given the animus evident in the executive order, calling identity corrosive, the claim of discrimination is far more than just colorable. It's highly persuasive.
So we have this fundamental tension. The majority sees the policy as a neutral historical fact. The dissent sees it as an act driven by discriminatory animus, hastily and improperly implemented. And in the context of a stay, that disagreement should have meant the court preserves the injunction and prioritizes the plaintiff's safety.
Exactly, which brings us right to the core of the balance of equities argument. The concrete injuries to the plaintiffs that the dissent felt the majority completely ignored.
This is Section 4, the human impact. This is where all the abstract legal principles meet immediate lived reality. What did the district court actually find about the harm to the plaintiffs if the injunction was lifted?
The district court had conducted a full evidentiary hearing, and it found that plaintiffs would suffer concrete and irreparable injuries. And this moves the whole discussion past, simple inconvenience and into immediate danger.
What were those specific injuries?
They're categorized into two main areas, starting with just profound psychological and emotional harm.
Okay.
The trial court found that transgender people who face obstacles in getting gender-congruent ID documents are almost twice as likely to experience suicidal ideation.
Twice as likely.
And they report more severe psychological distress compared to those who don't face those barriers.
That's a staggering finding. We are literally talking about a policy that directly exacerbates a mental health crisis.
It is a matter of life and death, psychologically speaking. And compounding this is the immediate physical safety risk. The court record shows unequivocally that using gender-incongruent passports exposes transgender people to increased violence, harassment, and discrimination.
And especially at airport checkpoints.
Particularly at stressful and invasive airport checkpoints, where your identity is scrutinized most intensely.
This is the part that just demands attention. We have to look at the specific anecdotes that were documented in the court record, because they show the reality of presenting documents that intentionally misrepresent who you are today.
The dissent cited 4 specific examples from the record, and they really testified to the brutal reality of this disconnect.
Let's go through them.
First, A.C. Goldberg, a transgender and intersex person, testified that he has been sexually assaulted by Transportation Security Administration TSA officers during security screenings.
I just want to pause there. Sexual assault. During a mandatory government security procedure, the document discrepancy is actively creating a risk environment that leads to violations of physical integrity.
The testimony really underscores the gravity of the scrutiny. Then we have Chastain Anderson, who attested to having been strip searched when she was traveling with documents that did not match her gender expression.
Strip searched. I mean, this is humiliating. It's invasive. It's a severe breach of personal dignity.
Yeah.
And it's forced by the disjunction between the person and the government document.
These are not isolated incidents of discomfort. They are documented instances of severe bodily violations at the hands of federal agents triggered by the ID.
What's the third example?
A third plaintiff, Zaya Parisian, was subjected to invasive pat-downs by TSA agents who were specifically trying to confirm her gender after they saw the obvious mismatch between her female gender expression and the male sex marker on her passport.
So the document, which is supposed to facilitate identification, instead functions as a trigger for intrusive investigation.
It turns a routine travel moment into this enforced moment of verification and confrontation.
And there was a fourth.
And finally, plaintiffs Ashton Orr and Ray Gorlin recounted being accused of presenting fake identity documents. And they were forced, under duress, in a security setting, to out themselves as transgender and non-binary to TSA agents.
That forced disclosure, that outing, it's a profound invasion of privacy. And it's a highly vulnerable position to be put in.
So when you lay out these specific documented harm, sexual assault, strip searches, invasive pat-downs, forced outing, and the documented risk of suicidal ideation, it absolutely throws the government's abstract claim of being irreparably harmed by a policy delay into stark negative relief.
That is the precise point the dissent concluded was ignored. Without the injunction, the affected class is forced into this documented, terrible choice that no other Americans have to make.
And those two choices they're truly untenable.
What are they?
The first choice is to use gender-incongruent passports and risk harassment and bodily invasions, as we just saw from the plaintiff anecdotes.
And the second choice?
Is to avoid all activities that require a passport, which means giving up international travel and often critical domestic activities like opening bank accounts, renting cars, or starting new jobs that require primary ID verification.
So they are being asked to choose between physical risk or sacrificing fundamental liberties and aspects of modern citizenship.
The harm to these individuals is palpable, it is immediate, and it is well documented. And the dissent concluded, unequivocally, that the documented real-world harms obviously outweigh the government's unexplained and inexplicable interest in immediate implementation of the passport policy.
And the dissent's final words on this are just. They're cutting. They call the court's refusal to answer equity's call an abdication of the court's duty.
An abdication of its duty to apply equitable standards equally to all litigants, to the vulnerable individuals and to the powerful government alike.
It's a procedural argument that uses human rights and safety as its foundation.
It is. The dissent is arguing that the court is failing its most basic function when it permits significant, documented, and irreparable harm to individuals just to allow the executive branch to proceed immediately with a policy whose legality is still hotly contested and remains under judicial review.
That concludes our deep dive into the procedure, the policy, and the people immediately affected by this Supreme Court order.
So let's just synthesize the central tension one last time for you, the learner. This case is a collision of executive power driven by an explicit political characterization of identity.
Right, in Executive Order 14168, which used words like false and corrosive.
And that collides with 33 years of administrative practice built on safety and utility.
And all of that policy conflict was judged through this narrow, high-stakes lens of emergency equitable relief standards, where the government successfully argued that a delay in implementing its preferred definition of identity was a greater, more irreparable harm than the documented risk of sexual assault and psychological distress to its own citizens.
The lesson here is that stay orders are not just technicalities. They are fundamentally about balancing harm. That's the Ninkin standard. And the majority accepted the government's claim that preventing the sovereign from executing its policy on foreign affairs documents is an irreparable injury.
But the dissent hammered home that the perception of irreparable harm differs drastically. It's the contrast between the government's abstract policy goals and the individual citizen's daily reality, their safety, their psychological well-being. And this case shows which harm the court prioritized in this emergency context.
The majority viewed the policy's delay as the greater harm. The dissent viewed the immediate infliction of physical danger and psychological distress on vulnerable citizens as the greater harm. And that judicial choice, made under the guise of an emergency stay, has profound, immediate, and tragic consequences.
So as we close out, there's one provocative thought for you to carry with you. The majority opinion explicitly claimed that displaying sex at birth is simply attesting to a historical fact, kind of like a country of birth. Given the plaintiff's detailed experiences in the dissent, the invasive searches, the strip searches, the forced outings, what implications does this judicial framing of historical fact have when that very fact directly conflicts with a person's current lived identity? And that conflict is then systematically used to justify intrusive, humiliating scrutiny by government agents.
It forces us to ask whether the judiciary is merely certifying a neutral historical reality, or whether it is lending the heavy weight of the law to a politically motivated definition of identity, a definition that results in documented, tangible danger and strips individuals of their fundamental right to move safely in the world.
The distinction neutral fact versus active tool of scrutiny is the question we're all left with, as this case makes its slow way through the appeals process. Thank you for joining us for this crucial deep dive. We'll see you next time.